Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we cover Cox Communications versus Sony Music Entertainment, a 9-0 decision handed down on March 25, 2026. Justice Thomas wrote the majority opinion for 7 justices. Justice Sotomayor wrote an opinion concurring only in the judgment. Justice Jackson joined this concurring opinion. At bottom, the court reversed a $1 billion copyright verdict and ruled that an internet service provider does not bear legal responsibility for its customers' copyright theft simply because the provider knew that theft occurred on its network. This case matters to every streaming user, every musician, every internet company, and frankly, anyone who pays a monthly internet bill.
And that $1 billion number, that's not a typo. We're talking 10 digits.
10 digits? Gone, at least for now.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. Cox Communications runs one of the largest internet providers in the country, roughly 6 million subscribers. Think about that. 6 million households, coffee shops, college dorms, businesses, all connected through Cox's infrastructure.
And somewhere in that massive network, people steal music.
A lot of music. Sony Music Entertainment and other major record labels, we're talking the heavyweights of the music industry, knew their songs were showing up on illegal file-sharing networks. So they hired a company called MarkMonitor to track down the thieves. MarkMonitor deployed software that scanned the internet for illegal uploading and downloading of copyrighted songs. When the software detected theft, it traced the activity back to a specific IP address. That's the unique numerical identifier that marks the source of internet activity. Identified which internet provider owned that address, and then fired off a notice to the provider.
A notice saying, hey, one of your customers stole this song.
Exactly. And over roughly 2 years, MarkMonitor sent Cox 163,148 of those notices.
That's not a rounding error. That's a pattern.
That's a pattern. And here's where things get interesting. Cox maintained what it called a graduated response system. First notice, second notice, warning letter. Keep going. Cox suspended that IP address until the subscriber called in. After 13 total notices, the subscriber faced full termination. Cox also buried a clause in every subscriber contract prohibiting customers from copying or transmitting anyone else's copyrighted material.
So Cox wasn't completely ignoring the problem.
That's exactly what Cox argued. Cox claimed its system resolved 98% of identified infringement, but Sony countered with a very different picture. Sony pointed out that during the same period Cox received all those notices, Cox terminated only 32 subscribers for infringement, 32. Meanwhile, Cox terminated hundreds of thousands of subscribers for non-payment.
So Cox would cut off your internet for not paying your bill faster than it cut off your internet for stealing music.
That's Sony's argument in a nutshell. Sony also surfaced internal communications, emails and messages from Cox employees, expressing frustration with the MarkMonitor notices and an apparent reluctance to act on them in order to protect subscriber revenue.
That's the kind of evidence that sounds really bad in a courtroom.
It did. The jury agreed with Sony on both of its legal theories and found Cox's infringement willful. The verdict, $1 billion in statutory damages, meaning damages set by statute rather than calculated from actual losses. Walk me through what happened in the courts before this landed at the Supreme Court.
The case started in the Eastern District of Virginia. The jury sided completely with Sony, contributory liability, vicarious liability, willful infringement, and handed down that $1 billion award. The district court upheld it.
2 theories of liability. What's the difference?
Contributory liability, the one at the center of this case, means you contributed to someone else's infringement by providing the means to infringe, with the intent that they use it that way. Vicarious liability means you controlled the infringer and profited directly from the infringement. 2 different roads to responsibility.
The Fourth Circuit, that covers Virginia, Maryland, the Carolinas, West Virginia, affirmed on contributory liability. The court reasoned that simply supplying a product while knowing the customer will use it to infringe copyright sufficed for liability. That's a significant expansion of the standard. The Fourth Circuit reversed on vicarious liability, finding Cox didn't profit directly enough from the infringement itself. The court vacated the damages award and sent it back for a fresh calculation, so Cox still faced a massive damages retrial until the Supreme Court stepped in.
Right. The Supreme Court granted Cox's petition on contributory liability only, declined to revisit vicarious liability, and heard arguments on December 1st, 2025, March 25th, 2026. The ruling drops.
So what legal question did the court actually decide?
Here's the formal question. Can an internet provider bear contributory copyright liability for its customers' infringement if the internet service provider continues to serve subscribers it knows have stolen copyrighted material? In plain English, if you know your customer steals music, do you become a music thief too?
That's it. And the Copyright Act itself does not answer that question. The Act makes infringers liable, but it says nothing about the companies that supply infringers with tools or services. Courts developed secondary liability, meaning responsibility for what someone else does, through decades of judge-made law rather than explicit statutory command. And that judge-made law comes from two big Supreme Court precedents, two cases. First, Sony Corporation of America versus Universal City Studios. That's a 1984 decision involving the Betamax 5CR. Copyright owners sued Sony claiming the VCR enabled people to copy television programs. The court declined to hold Sony liable because the VCR served substantial lawful purposes, like recording a show to watch later, even though it could also enable copying. The principle: if a product serves significant legitimate uses, selling it to the public doesn't make the seller a copyright infringer.
The tape recorder case.
Exactly. Second, Metro-Goldwyn-Mayer Studios versus Grokster, 2005, the peer-to-peer file sharing case. Grokster distributed software that its operators specifically advertised as a successor to Napster, a previous illegal music sharing service. They marketed the software to known copyright thieves, built their business model on high-volume infringing use, and declined to filter illegal content. The court found those companies liable, not because of what the software could do, but because of how the companies actively promoted it.
So Grokster drew a line. Actively push people toward infringement, you're liable. Passively sell a general-purpose tool, you're not.
Precisely. And that line is exactly what this case tested.
The court laid out the legal framework this way. Contributory liability requires proving that the provider intended for its service to enable infringement. And intent, here's the crucial point, can come from only two sources. Either the provider actively induced customers to infringe, or the provider designed its service specifically for infringing use, meaning the service lacks any commercially significant legitimate purpose.
Knowledge alone doesn't cut it.
Knowledge alone doesn't cut it. The court walked through three prior decisions that all said the same thing. Back in 1911, Kalem Company versus Harper Brothers, the court explained that mere indifferent supposition or knowledge that a buyer will use a product unlawfully doesn't make the seller responsible. In Sony in 1984, the court found no precedent for liability resting solely on awareness that customers might infringe. And in Grokster in 2005, the court confirmed that courts cannot find contributory liability merely based on a failure to take affirmative steps to prevent infringement.
Three separate decisions across more than 90 years, all pointing the same direction.
So, the court applied the test to Cox. On inducement, did Cox actively encourage its subscribers to steal music? No evidence. Sony produced no marketing, no promotional materials. Nothing from Cox saying, use our internet to download music for free. Cox actually discouraged infringement by sending warnings, suspending accounts, and terminating subscribers.
Even if they only terminated 32 people.
Even then, the question under the inducement standard isn't whether Cox did enough to stop infringement. The question is whether Cox actively pushed people toward it. Cox didn't.
And the other prong, did Cox design its service specifically for infringing use?
Cox provided internet access. People use internet access to work, stream videos, video call family members, run businesses, do homework, pay bills. The court found Cox's service clearly capable of substantial or commercially significant non-infringing uses, the test from Sony, and that dooms the tailoring argument completely.
So the Fourth Circuit got it wrong.
The Fourth Circuit invented a third form of contributory liability that the Supreme Court's precedents never recognized. The Fourth Circuit said, supply a product while knowing the buyer will infringe. That's enough for liability. The Supreme Court said, no. That rule directly contradicts decades of precedent. Reversed. And Cox's counsel at oral argument acknowledged that under the majority's rule, Cox faces, quote, no liability risk based on knowledge alone.
Which sets up the concurrence perfectly. Justice Sotomayor filed a concurrence in the judgment only, joined by Justice Jackson. That means they agreed Cox shouldn't lose this case, but they got there a completely different way. So Justice Thomas writes for 7 justices. He sets the rule. Sotomayor and Jackson agree Cox wins, but they disagree sharply with how the majority reached that conclusion.
What's her objection?
Sotomayor argues the majority unnecessarily, her word, closed off other forms of secondary copyright liability that Grokster expressly left open. Specifically, she argues the court should examine whether a doctrine called aiding and abetting, a centuries-old common law rule holding people responsible when they intentionally help someone do something wrong, might apply to copyright cases.
Aiding and abetting in a copyright context. That's not something we normally hear.
The court recently applied aiding and abetting analysis in 2 other secondary liability cases, Twitter versus Tomney in 2023, involving ISIS terrorism, and Smith & Wesson Brands versus Estados Unidos Mexicanos in 2025, involving gun manufacturers and Mexican drug cartels. Sotomayor argues those cases establish the framework for analyzing when someone who knowingly assists a wrongdoer bears legal responsibility.
And the key to that framework?
Intent. Under aiding and abetting, you bear liability when you consciously participate in wrongful conduct with the intent of helping it succeed. Critically, and this is where Sotomayor uses a vivid example, intent can sometimes arise from knowledge. If you hand a loaded gun to someone knowing with certainty they will shoot another person, you can bear liability for the shooting even if you personally didn't want anyone shot.
So pure knowledge can equal intent in certain circumstances?
In certain circumstances. But, and here's why Cox still wins under Sotomayor's framework, aiding and abetting liability typically requires knowing who the specific wrongdoer is. Cox receives notices identifying an IP address. An IP address points to a household, a coffee shop, a college dorm, a regional internet provider serving thousands of downstream users. Cox cannot identify which individual at any given address committed infringement.
So Cox knows that infringement occurred somewhere on a connection it supplies. Cox doesn't know who committed it.
Exactly. Sotomayor compared Cox's position to the gun manufacturers in Smith & Wesson, companies that sold firearms to middlemen distributors without knowing which downstream dealers redirected those guns to drug cartels. The court rejected liability there for the same reason. The manufacturers lacked specific knowledge of the individual wrongdoers. Cox faces the same informational gap.
So Sotomayor gets to the same result. Cox wins. But she leaves the door open for future plaintiffs who might gather more specific evidence of individual infringers.
And she fires a warning shot at Congress. The majority's rule effectively renders the DMCA's safe harbor provision worthless. Under the majority, ISPs face no realistic risk of secondary copyright liability no matter what they know or refuse to do. Cox's own lawyer conceded at oral argument that the safe harbor provision would not do anything at all going forward. Sotomayor says Congress did not create that safe harbor just so the court could gut it.
9-0. Justice Thomas wrote the majority. Cox wins. The Fourth Circuit's judgment reversed and remanded.
The billion-dollar verdict, gone, at least on this theory. The case goes back to lower courts for further proceedings, and the legal principle now stands: an internet provider does not bear contributory copyright liability simply for continuing to serve subscribers it knows have stolen copyrighted material. Proof of intent to enable infringement requires either active inducement, marketing and promoting infringement, or a service designed for no purpose other than infringement.
Okay, let's talk about what this actually means.
For internet providers, Comcast, AT&T, Verizon, every regional ISP in the country, this closes one of the biggest legal threats they faced. Rights holders no longer can hold providers financially accountable simply for maintaining accounts of known infringers, which means the pressure on providers to police their own networks drops significantly. Cox's lawyer conceded that point at oral argument. Under this ruling, Cox could theoretically abandon its graduated response system tomorrow and face no legal consequence under contributory copyright liability.
For musicians, filmmakers, authors, publishers, the major rights holders, this stings. They lose a litigation weapon that could have forced ISPs to aggressively terminate repeat infringers. Pursuing individual infringers online remains theoretically possible but practically difficult given how widespread piracy runs.
And that's the tension this case never fully resolved. Sony terminated only 32 subscribers for infringement during the claim period. but pursued Cox for $1 billion. The individual infringers stealing the music never faced a lawsuit. The entity that provided the pipes did. The court said, that's not the law.
Justice Sotomayor's concurrence keeps one door cracked. A future plaintiff who builds a specific, individualized record, showing that an ISP knew the identity of individual infringers, not just the IP addresses, might survive under an aiding and abetting theory.
That's a very high bar, and it likely requires legislative action before rights holders see real results. The DMCA safe harbor argument Sotomayor raised signals directly to Congress. The incentive structure you built in 1998 no longer functions the way you intended. Congress may revisit the statute. Watch for legislative proposals in the next few years.
The practical bottom line, if you pirate music or movies, the Supreme Court just made it harder for the music industry to use your internet provider against you. Your internet provider, in turn, now faces less legal pressure to cut off your service.
Whether that outcome squares with what Congress intended, that's the question this decision leaves hanging. Bottom line on this one, the court drew a clear boundary. Provide the internet connection, no infringement happens on it. That combination alone doesn't make you a copyright thief. The court demanded proof of actual intent, active encouragement, or deliberate design, before attaching billion-dollar liability to a company that supplies a general-purpose tool to the public. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And look, if the music industry can't get $1 billion from the company that sold the infringers their internet connection, at minimum, you can leave us a 5-star review. That costs you nothing. Unlike Cox's legal bills.
Talk to you soon.